Morning, everyone. I think we can get started. So my name is Nina Murray. I'm Head of Policy and Research at the European Network on Statelessness. And it's a real pleasure to welcome you all on behalf of ENS to the webinar, Credibility Undermined, Challenges Faced by Stateless Asylum Seekers in the UK. For those of you not familiar with ENS, we are a civil society alliance of over 180 organisations and individual experts working to address statelessness in 40 European countries through law and policy development, awareness raising, and capacity building. We were very excited to have more than 200 people registered for the webinar today, and it's great to see many of you joining us already. And we look forward to welcoming you all. Please feel free to say hello in the chat and tell us where you're joining from. We're also going to post a quick poll now just to find out a bit more about our audience today and who is joining us. So you can see the poll there. It'd be great if you could complete that. Good morning. Welcome, everyone. Thanks for saying hello. You can also use the chat function throughout the webinar to share questions and comments. We have set time aside for a live Q&A with our speakers at the end, so I will put some of your questions to the speakers at the end. Good morning, nice to see everyone where you're all coming from. Belfast, Stockholm, Switzerland, Sheffield, good to see you all, welcome. So the purpose of today's webinar is to present new research on challenges in determining country of origin for stateless asylum seekers in the UK, with a focus on the experiences of stateless Kurds from Syria. The full research report and an executive summary in English and Arabic are available on our website now, and colleagues will be posting the links for you in the chat in case you haven't come across those yet. So the research findings are relevant for different actors interested in working on or affected by statelessness and asylum, not only in the UK, but also in other countries receiving stateless asylum seekers. So it's great to see a diverse audience from across Europe and beyond here today. The research was carried out under ENS's Stateless Journeys project, which aims to improve routes to protection for stateless refugees in Europe. Together with our members and partners across Europe, the project has been working to evidence the issues faced by stateless refugees and asylum seekers, to build the capacity of refugees and civil society and relevant authorities. We've been running a campaign to mobilize and inspire action on the issues. And we're also using this increased visibility to work with our partners to try to achieve law and policy reform, both at regional level and national level. And you can find out much more about this project, about the resources that we've been producing, and also importantly about the experiences of stateless refugees and some of their stories on our Stateless Journeys website, which colleagues will post a link to in the chat now as well. There are lots of different resources on the website, so please do have a look. Just to find out a little bit more about who you all are today, we're going to post another poll just asking about your connection to this issue and in what capacity you work on the issue, and also whether you see statelessness as being relevant to your work. So we'd be grateful if you could answer that, just to get a sense of your interest in the issue. So back to today's webinar. We are really excited to have an excellent panel of speakers for you today. Firstly, we have the report's author, Thomas McGee, who's going to present the research findings and recommendations. We're then going to hear from Cynthia Orchard, who is a consultant on migration, asylum and nationality issues, and also an advisory committee member of ENS. And she's going to tell us about the report's relevance to wider UK law and policy on statelessness and some of its regional implications. And then last but not least, we're going to hear from Fatima Ali of Asylos about how to address statelessness in country of origin information and some of their work on this issue. And as I said earlier, we will have time for questions at the end, so please do feel free to think of questions and already post them in the chat, and we'll respond to as many as we can at the end. So without further ado, I'm going to welcome Thomas. If you can switch your camera on, Thomas. Who is as I said, the author of the research being presented today. Thomas is an individual ENS member from the Peter McMullen Centre on Statelessness at the University of Melbourne Law School and co-convener of our sister Statelessness network for the MENA region, Hawaiiati. So Thomas, I'm going to hand over to you. Thank you.
Thank you, Nina. I hope you can hear me. I hope you can see the slides as well. So it's great to see such a good turnout. First of all, I'd like to start by thanking everyone who's played a role in supporting this research to come about. I have to say it's been quite a long journey, and I'm really grateful to first of all the ENS staff who've so patiently supported and facilitated this work. At the same time, I'm grateful to the various stakeholders who shared their expertise to strengthen the content and recommendations of the report. Critically, I'm also very indebted to the individual asylum seekers and refugees affected by statelessness who were willing to participate in the research and share their perspectives. By way of very quick background, the report that we've just launched takes quite a narrow focus. As Nina explained, it looks specifically at the experiences of stateless asylum seekers in the UK as they seek to determine, as they go through the process of their country of origin being determined within the asylum system. So before launching this research and surveying what literature was already out there, there was quite a bit on how previous research had identified that stateless asylum seekers and refugees often perceive their statelessness to increase vulnerabilities at various stages of the asylum journey. Indeed, ENS's Stateless Journeys project, as Nina mentioned, has highlighted the multiple challenges that stateless people often face relating to cross-border mobility, registration with the authorities, access to family reunification, and naturalization. But relatively little research has been done on how the asylum procedures actually function in practice for stateless asylum seekers. In the UK context, this was also quite striking. That considerable research, valuable research, had been conducted on the parallel statelessness determination procedure, the SDP, but little comparable research had been done on how the procedures of the asylum route operate. This is perhaps surprising when we consider that statistically, stateless asylum seekers or those that have had their status as stateless recognized far outnumber those who've gone through the SDP. So basically, as we were conceiving of this project, I'd come across lots of anecdotal reports about statelessness and how statelessness hadn't been properly picked up upon or had been misunderstood within the asylum process. What this report seeks to do, therefore, is to actually present an initial evidence base beyond just the anecdotes that I'm sure many working in the sector have come across, to have a basis of evidence that we can present to indicate whether or not stateless asylum seekers experience disadvantages in determining their country of origin. So that means, do they experience additional challenges beyond those faced by asylum seekers who are citizens from the same country? As already mentioned, this research report began a number of years ago. So it's important to note that in the UK context, there have been a number of changes and significant changes to the asylum system since then. Given the narrow focus of the report, I'm not actually going to be referencing these changes within the presentation, but it is worth bearing in mind that future asylum seekers are certainly navigating a quite different landscape to the one that existed when this research first began. Ultimately, also, while the focus is very much on the UK context, I do hope that there is relevance for other country contexts, and at least in provoking questions that might be relevant to ask elsewhere. So, as Nina mentioned, this report specifically focuses on stateless Kurds from Syria who have applied for asylum in the UK. This profile was chosen as a focus largely for pragmatic reasons, given my own familiarity with the context and established networks among Kurds from Syria. That was largely due to previous research I conducted on the issue of statelessness in Syria and those displaced from Syria to neighboring countries over the last decade or a bit more. Again, I really hope that at the same time, some of the findings can be relevant for other profiles of people faced by statelessness. So in terms of methodology, for this report, I conducted 15 semi-structured interviews with stateless Kurds from Syria who had claimed asylum in the UK. Of those 15, 8 presented their paperwork and permitted me to review their paperwork as part of the research process. This often included decision letters and interview transcripts among other documents. In addition to this, I spoke to various relevant stakeholders. This included solicitors, professionals with legal, country, and linguistic expertise, who were able to speak to the wider context and trends, and that helped with triangulation of findings. Okay. So one phrase that was recurrent in the decision letters that I reviewed was this one that you see on the screen: "Your claim to be a Syrian national is disputed." It's actually quite odd, since all of the claimants had made references in their transcripts to their statelessness, some more explicitly than others, some directly using the term stateless, others it was more alluded to. And I'm just going to quote one case that's cited in the report. So one individual stated, "When I arrived, the Syrian conflict was in the headlines every day, so Syrians were getting accepted easily. My case was fairly straightforward. I stated that I was stateless from Syria, but this was not focused on at all. As my case progressed smoothly and quickly, I saw no reason to bring up my statelessness again. However, later, when I reviewed my case, and after being granted asylum, I realized that I was processed as if I were a Syrian citizen, and my statelessness was not even considered at all." So one thing that I noted is that when the Home Office, the Home Office tends to engage with such cases as disputed nationality cases, which is actually going against its guidance that has a separate category of cases which are disputed statelessness cases. So in the case that a claimant has presented as stateless, and the Home Office is doubtful of that, it ought to be considered as a disputed statelessness case. But in practice, they're being based on, and the separate language that's used for these two different types of cases. In practice, this led to a lot of confusion because you would get phrases such as the one on the screen. Your claim to be a Syrian national is disputed, and the individual in question is essentially saying, but I never actually claimed that. That isn't what I claimed. So this led to lots and lots of confusion as cases developed, as they went to appeal, because people ended up in a situation where they were somehow appealing against something that wasn't actually what they themselves originally claimed, and the language was getting really confusing between you claim to be a Syrian national and then people are saying, but actually I didn't, or were very confused about whether they should again bring up the fact that they're stateless. So this was, in fact, in all of the refusal letters that I reviewed within the detailed reasons for refusal section, in all 8, it stated the term Syrian national throughout the reporting, and there said, you claim to be a Syrian national, with no reference to the claimed statelessness. Just to quote one individual's perspective on that. So somebody that I interviewed, one of the 15 people, said, the whole thing was very confusing for me. Should I argue that my nationality is not Syrian, while the Home Office is trying to say that I am not from Syria? I am from Syria. It is where I've lived all of my life before coming here. It is not a lie to say I am Syrian, but I was deprived of my citizenship. Maybe this is important to explain. It was also part of the reason I saw no future in Syria, and maybe this government, meaning the UK government, should know that I am not a citizen of any country. So this is just an example of the confusion that it created on the individual level. In general, the report highlights 3 areas where the procedures used to determine country of origin seem to disadvantage stateless asylum seekers, or at least stateless Kurds from Syria claiming asylum. Those are civil documentation, first of all, so the documents that people were able to present, referring to their identity. Number 2, knowledge of local contexts, and this refers to the kind of questions that the Home Office staff tend to ask to elicit responses to be evaluated in terms of whether it seems that somebody is really from that country or not. And thirdly, language analysis. So whether it's determined that an individual's way of speaking fits onto their claim to be from a certain country. Now I'm going to go one by one through those 3 themes and just give a flavor of some of the findings that came up. So first of all, on civil documentation, it was often the case, almost exclusively the case, that very little weight was given to the documents presented by stateless Kurds. That's largely because the only document that a stateless Kurd from Syria would usually be conceivably hold is in Arabic, it's called Shahadat Tarif, certificate of identification. And the format of this document is a very flimsy A4 piece of paper. It's filled out by hand by a local official. It has no hologram, no biometric, no fraud-resistant mechanism. But significantly, it's the only document that many stateless Kurds would conceivably be expected to hold, so wouldn't be able to present alternative documents. In addition to the lack of consideration, many of those I interviewed referred to the way that their documents were dismissed, and how the process of that happening was actually quite painful. So one judge is cited as saying, "I see no evidence that the relatively skilled forger could not have reproduced this document with a modicum of effort." While that may well be the case because the documents are so simple and filled out by hand, again, it doesn't take into account that a stateless person wouldn't, in most cases, have any alternative document to present. So one individual here stated, "They will never understand the intensity of my relationship to this piece of paper." He went on to explain how he would carefully fold it up and ensure he had it on his person at all times when in Syria. He said, "It was the only document I had that made me feel a little bit like a human my entire life in Syria. It carries mixed emotions. It was worthless and a symbol of the discrimination against me, and the fact that I hated the fact I had to carry this paper with me. But at the same time, it was precious as it could keep me out of prison if ever stopped by the police." He further reflected, "I understand that this document does not look as official as a passport, but it is all I had. I have no way to prove it's real, but that does not mean it is not real." It was painful to see the judge in the UK dismiss it without even a second thought. And then actually, according to Home Office guidance and case law practice, such documents should be considered not in isolation, but evaluated in the round. This is the phrase that is used, meaning as part of all the evidence available. Yet in practice, there was often little indication that this was happening. Moving on to local contextual awareness. Quite simply put, many of the questions asked to stateless asylum seekers tended to have a bias towards the experiences of Syrian citizens. And moreover, generally the mainstream Syrian citizen that might be living in the capital, for example. So a lot of those questions referred to national public holidays, which and no consideration was given to the fact that many stateless Kurds were primarily excluded from such mainstream culture. For example, a stateless Kurd couldn't have joined a lot of public sector government celebrations, couldn't join the structures that are related to the leading party where a lot of these festivities are celebrated. Moreover, nationality testing, it's been argued elsewhere, often doesn't work very well for minorities. And it should be noted that according to UN reports, an estimated 75% of stateless people globally are believed to belong to minority groups. Within the report, there's a lot more examples relating to this presented, but this is just to give a quick flavor. The final part is on language analysis. And honestly, the data that came out on this was really enough to have been a whole report on its own. Given that I'm not a trained linguist as such, I kept it quite straightforward. I do speak Arabic and Kurdish, and based on that alone, it was clear that just some of the conclusions that were reached through language analysis were quite farcical. I'm aware that there's ongoing debates among linguists on approaches to language analysis to determine country of origin and the deficiencies of certain approaches. So I'm not going to go into that debate much, but just to highlight that Kurdish is a language that hasn't been fully mapped out linguistically. There's lots of internal variation between different Kurdish settlements in Syria. And also, as with a lot of languages, it's not the case that language patterns immediately stop and are reflected by the country borders. In many cases, I saw that quite bizarre kind of arbitrary rules were being created, often around synonyms. So I guess one way to explain it is just if you had a kind of an equivalent is if somebody were to come up with a paradigm to say, in England, people use the word city, but in Scotland, people use the word town when using the phrase, I'm going into town, I'm going to the city centre. So this, I think we would all dispute and say, well, not really. But they were presented as hard and fixed rules upon which we could it could be determined, is this a Kurd from Iraq, or is this a Kurd from Turkey, or is this a Kurd from Syria? I guess, not wanting to go into further details on this, quite a striking example of the farcical situation is that one individual did language analysis in Kurdish and was concluded to be Iraqi. His legal representative urged him to consider doing the test again in Arabic, because he was also a comfortable Arabic speaker. And he stated that he often preferred to speak in Arabic. When he did it in Arabic, he came out as Lebanese. So this just states some of the doubts that we have in how can this individual be from two different countries. Coming on very briefly to conclusions, I'm not able to present all of the recommendations covered in the report, but I would really encourage anybody interested to read through those. As Nina mentioned, we have a 2-page document that's just an executive summary and recommendations. But overall, so a lot of the recommendations are on, so some are focused on particular actors, but others are more general. Some of the more general ones are relating to the need for training and sensitization about what it means to be stateless and going through this process. Also support the idea of conducting internal and external audits on the Home Office procedures for stateless applicants. This could be something that's similar to the audit that was undertaken with UNHCR on the SDP fairly recently. Additionally, just to review the procedures, how is language analysis being implemented, contextual knowledge likewise, and what are the implications for those who are stateless. Finally, and I'm not going to go into it in any detail because our colleague Fatima will cover it more, but just country of origin information report should always reference statelessness if there is a significant stateless situation or community. In the case of Syria, I know that there's so much going on in Syria. Things are changing very rapidly. There's so many armed groups that have to be described in these reports, but the current UK country of origin information on Syria doesn't have a single reference to statelessness, to my knowledge. So I would hold there and look forward to the rest of the webinar. Thank you so much.
Thank you so much, Thomas, for that really comprehensive overview of what is a really interesting and important report. So I do urge everyone to take a look and read the very detailed examples in the report to illustrate some of the points that Thomas has been making. And we will come back to country of origin, and we can come back to questions that might be coming up at the end. But I'm going to move quickly on now to our next speaker to make sure we have time to hear from Cynthia and Fatima. So I'm delighted to welcome Cynthia Orchard, who, as I said, is a consultant on migration, asylum and nationality issues and an ENS individual member, an advisory committee member. Cynthia is going to expand on some of the points that Thomas made and the relevance of the report for wider UK law and policy on asylum and statelessness, and discuss some of the regional implications as well. So Cynthia, thank you. Over to you.
Thanks, Nina, and congratulations to Thomas and to everyone at ENS who was involved in producing this report. And hello to everyone. It's a pleasure to join you today. I wanted to just start by saying how really vital this research is. It's really compelling and showing how important it is to address statelessness in asylum procedures. And as Thomas mentioned, I think this is an area that definitely needs further research, and this is a really great start, and really, really important. So well done, Thomas. I wanted to also just acknowledge that I'm not stateless. I have 3 nationalities. One of them I acquired recently because I was not able to acquire my mother's nationality at birth because of a nationality law that discriminated against women. And in the process of acquiring Canadian citizenship recently, it really kind of hit home to me, even though my problems were minuscule compared to what most stateless people go through. On that front, it really did bring home to me how difficult it can be to deal with addressing issues of acquisition of nationality. I have worked in the UK previously as a legal advisor with asylum seekers and with stateless people going through the UK's statelessness determination procedure. I don't work as a legal advisor at the moment. I do more research and policy and advocacy. But I will say that some of these issues, most of what Thomas has said this morning and in the report, it doesn't surprise me at all. It sounds very, very familiar from a lot of the cases that I dealt with as a legal advisor in the UK. And it certainly isn't limited to stateless Kurds from Syria. Unfortunately, very similar issues arise for other stateless people, including in cases that I dealt with, for example, a Palestinian from Libya, a stateless person from Abkhazia, and a stateless person from an African country who grew up in a border area and spent a lot of his time traveling back and forth between countries, but never had very many documents. So these kinds of issues arise in lots of different contexts. One of the commonalities that occurs in lots of these cases is that statelessness is often ignored completely in the asylum context or is grossly misunderstood. And the result very often is an unjust refusal of refugee status, and or a very, very long time to reach a successful resolution of a case. And of course, that is incredibly traumatic for the individuals concerned. And it has a toll on them in so many different ways, including on their mental health. And I have worked with quite a few people who have really suffered from the impact of these issues of their statelessness being ignored. I will also just say briefly a little bit about the UK context now. And as Thomas mentioned, things have been changing over time since he began this research, and they are getting worse and worse in the current climate. As some of you will know, the Illegal Migration Act was passed in Parliament in July of this year. It's not implemented in full yet. Some provisions have come into force recently, and they are already starting to cause problems for people. But if the Act is implemented in full, it will largely destroy the UK's asylum system for most refugees, because it will make most asylum claims inadmissible in the UK. It will likely increase the detention of asylum seekers, and it will make removal of people seeking asylum mandatory to a so-called safe third country. The country of choice at the moment is Rwanda, and there is litigation at the Supreme Court that's happening this week. So we will hopefully find out in the next couple of months what the Supreme Court's view is about the lawfulness of removal to Rwanda that the government wants to pursue. And we can all cross our fingers and toes that the Supreme Court will be compelled to find that that scheme is not lawful, because it very clearly has major problems in my view. I also just wanted to mention that this act will, of course, affect both stateless refugees and refugees who have a nationality. And also there are some potential exceptions built into the Act, but they will very likely be very, very difficult to access for many people, because it's already very difficult for asylum seekers in the UK to access competent legal advice, and things are likely to get even worse if this Act is implemented in full. And so the end result is that stateless refugees, as well as other refugees, will be even worse off than they are now. And potentially, this act will condemn stateless refugees to being shipped off to Rwanda and being potentially stateless forever. There are a few rays of hope. As I mentioned, there's the Rwanda litigation that's in the Supreme Court now. There will very, very likely be other litigation relating to the Illegal Migration Act. And there is hopefully a potential that the act may be at some point repealed, but we will have to wait and see for that. I'm going to stop there about the act because it's too much and too sad, but I try to hold on to some of those rays of hope. So I'm going to switch to talking a little bit about the Stateless Journeys campaign that I have been involved with in various capacities over the past couple of years, and just mention that the Stateless Journeys campaign more broadly has identified a lot of the similar issues to those which are raised in this report. For those of you who are kind of new to this topic, it would be really useful probably for you to have a look at the briefings on the Stateless Journeys website, in particular the briefings relating to asylum registration and screening, and refugee reception and status determination. That should give you a good background, and there are also links to where you can find other information on these issues. So I'm going to shift a little bit to talk now about some of the key reasons why it's so important to recognize statelessness in the asylum context and some of the really serious consequences that can occur if that doesn't happen. So some of the issues that Thomas has mentioned are really, really key. Some other issues that can come up for people include problems at borders. So if stateless refugees arrive at borders, they don't have any documents to prove who they are, they may be more likely to be denied entry and forced back into a situation of armed conflict. Of course, that can happen to refugees who have a nationality as well, but it is sometimes more likely to occur for stateless refugees. Unlawful detention is also a serious problem. If statelessness isn't identified in the asylum context, it can mean that a stateless refugee who is not recognized as a refugee or as a stateless person may be detained for a long period of time, even if their removal in fact is impossible because they are stateless. And if their statelessness had been identified and addressed much earlier in the procedure, then that would have been grounds for either not detaining them or for releasing them from detention much sooner. Another scenario in which this can be really important is when we think about what can happen at the end of an armed conflict. So sometimes conflicts, a civil war might end, and it may be safe in some situations for refugees who are nationals of that country to return to their country of origin. Of course, we need to make sure that it is in fact safe, that there is a real change. But for stateless refugees who are from that country, it may well not be safe for them to go back. And then finally, I'm going to just mention stateless refugee children. We know that refugees may not be able to transmit their nationality to children for a variety of reasons, including the statelessness of the parents, lack of documents, registration procedures that they can't access because they're refugees, or discriminatory laws that don't allow women to pass on their nationality to their children. And in that scenario, if children are not identified as being stateless, in some countries which have a procedure for stateless children to be granted the nationality of the host country, if the child's statelessness isn't identified, it means that child is missing out on a route to nationality and is more likely to grow up in poverty, instability, and denial of opportunities. I'm going to very quickly just mention a few solutions, and then I'll hand back over to Nina. So some of the solutions that we would really love to see include improved screening mechanisms, referral from statelessness determination procedures to asylum procedures and cross-referral. the introduction or improvement of statelessness determination procedures generally, and ensuring that they are effective to address the needs of stateless people and to ensure that they grant all of the rights that should be granted under the 1951 or the 1954 Convention. We also clearly need better credibility assessment and granting people the benefit of the doubt as should happen in credibility assessment. And we really clearly need to ensure better access to legal representation and interpreters. And Thomas's report really, really highlights how important that is. And of course, we need better training for frontline officials and others to enable them to competently address statelessness in the asylum context. And as Thomas mentioned, as we're about to hear from Fatima, we need more and better country of origin information that addresses the needs of stateless refugees.
Thank you so much, Cynthia. That was a real whistle-stop tour with lots of really useful information and pointers. I wish we had more time because there was so much in there. But thank you. And you can find a link in the chat to the Illegal Migration Act in the UK that Cynthia referred to, and you can find a lot more information about everything that Cynthia mentioned in terms of the regional recommendations and resources on our Stateless Journeys website. But without further ado, I want to move on to welcome Fatima Ali from Asylos. So welcome, Fatima. Thank you so much for joining us. Fatima is the program manager at Asylos, who's been doing some really interesting work on statelessness and country of origin information, and has agreed to share her reflections on Thomas's report and some more information about this work. So please, Fatima, over to you.
Thank you very much, Nina. I'm just going to share my screen. Right, so I hope everybody can see the slides.
We can see the full page. So if you can make them into slideshow mode, that would be great.
Okay, is that better?
Perfect, thank you. Go ahead.
Thank you. Okay, so first of all, thank you to Nina and all of ENS, as well as Thomas, for inviting me to represent Asylos at this fantastic launch of this report. It's wonderful to see it being publicized, and then to have this platform to be able to talk about the recommendations and the findings, etc. So I know we're kind of short on time, so I'm just going to dive right into it. If for those who don't know who Asylos is, we are a network of volunteer researchers. We are based all over the world, and we work on regions such as Africa, Asia, Russia, CIS, as well as MENA. And most of all of the work that we do actually is specifically researching COI, which covers both sides of international protection as well as statelessness applications. Our reports or our research basically includes a thematic research project, which is kind of the reason why we're here today, because it also links in with Thomas's work. And this is an idea for us to address COI gaps and also address a particular asylum seekers who don't necessarily have who are not covered in international media or international reports. Therefore, we try to identify those COI gaps and then produce a country report, which has a combination of interviews with people with lived experience or expertise on the topic, as well as publicly available information. And then we combine the two, and it sheds really good light on the situation of the country of HAPTA residence or country of origin of the applicants. Alongside that, we also publish case-specific research. With this, we compile individualized reports for NGOs as well as legal lawyers around the world, specifically on a case that they are working on, and they are behind a protected wall on our website, but you can access them if you are NGO based, etc. This is completely free of service. Usually takes about 5 weeks for a turnaround. And then if we have a look at the spotlight research, this is a fast changing situations that we are looking at. So we try to cover certain countries or themes that really need an emergency response to. And this is, again, of course, available on our website, and they are updated as needed. Then we also offer all year round, once a year, we offer COI training on a series of different specific topics. So we have child-specific research, disability, as well as now statelessness. The current statelessness workshops are ongoing, and we do have 2 more which are available on our website if anyone is interested. And then, of course, we have a few times a year, we do commentaries, which are basically reviewing governmental and intergovernmental organizations, COI products, and particularly looking at methodological shortcomings, and then suggesting points where they could further research. With all these services aside, we also conduct training for, we try to recruit and train at least 10 new COI researchers every year. So coming on to this particular statelessness, how Asylum became involved in it was we carried out a number of consultations that Thomas has actually mentioned in his report. And within those consultations, we identified various gaps. But before I go into that, I'm just going to touch on, you keep hearing about COI. So for those who, I'm pretty sure everyone in the room is very familiar with it. However, just to give a brief definition of what it is and what it includes, first and foremost, COI is actually information that's pertaining to the country of origin, or in this case, habitual residence of an applicant, and it can include information such as political, economic conditions, cultural references, etc. COI is really important when it comes to deciding an asylum applicant in terms of need of international protection, and of course in stateless applications. And COI is particularly important in this context because it really does provide you with the legal frameworks and the practices in those countries of habitual residence. And finally, but not least, it also helps us to identify stateless individuals and the risks and vulnerabilities that they face. So this, of course, can include things like barriers to education, or even the risk of detention or deportation. The consultations were also fed into a UNHCR audit that was done from 2020, or published in 2020. And this was specifically on the UK statelessness determination procedure, and it kind of gave us a baseline of all of the information, in particular that there is a lack of knowledge in terms of COI within decision makers, and there was a recommendation in there in regards that COI products being produced by the Home Office should include citizenship and frameworks, or nationality frameworks. Alongside that, the consultations actually brought up another point, which was directed to terminology, as Thomas mentioned, kind of touched on. And this is terminology and how incorporating of, particularly in COI, and how we are conducting research, that a statelessness might not even be a term used in the country of habitual residence. And finally, we did carry out an unpublished rapid review of a series of literature reviews, in particular in UK Home Office, as well as EUAA products. And this was very specific to looking at how they address stateless Palestinians in particular, because we ended up on that case study. Okay. With the document itself, I'm sure Francis can put the country report in the chat. But for today, we'll actually be discussing the principles, which is something that Thomas has referenced in his report, but he's also kind of touched on it indirectly in his own findings, and we would just like to reinforce them. So we're going to just go into them. Although there is 6 principles in total, we will only be going 3. We'll only be doing 3 because it's all we really have time for. But if we start with principle 3, which is terminology is key, here we were referring to the fact that not everybody uses the word stateless, for example, in the habitual residence. So therefore, you really have to look into how you can find out what other terms are being used, how it directly translates in that language. And Thomas mentioned like an Arabic word of Attendees, for example, which basically means foreigner, and that is a word that came up a lot in the Asylum Statelessness report as well. And there is a number of other references that we refer to. Terminology also includes when you are searching for, when you're carrying out COI research, there's other terminology you should be looking to in terms of statelessness. So statelessness itself might not bring up much information for you in that context. However, if you looked at marginalized individuals or discriminated individuals, these terms can also help you locate them. Practically speaking, as you can see on the screen, we do ask that you should be developing a really good understanding of those relevant terminologies, and that, of course, within the particular context that you're working on, and working with someone who directly speaks the language and also is familiar with the country context, they are incredibly insightful to be able to give you that information that you need. If we refer now to Principle 4, this is no single experience of statelessness. And you heard that in Thomas's report, there was various different interviewees and how they had experienced statelessness. And with this particular principle for the COI perspective, it is to connect it with a bigger approach that we have, which is our intersectionality approach. And this is the idea is that every stateless person in the world, even if they are in the same context, they definitely don't experience it exactly the same, because they have other multiple combined attitudes. So it could be things like race, it could be gender identity, it could be sexual orientation, or a number of other identities that kind of collide within and how they intersect together. So really, when it comes to the practical terms of looking at COI, you really need to identify in terms of how does the individual's core identities or number of identities, how do they actually collide with statelessness, and how do they intersect? And of course, you should contextualize that when you're publishing your information, so that it references other information such as socioeconomical, political context, cultural and social values. And then the final principle we're looking at today is Principle 5, which is understanding what the law says and what happens in practice. And this has been referred to a few times. And you can understand that laws and policies, including nationality, of course, are laws that are evolving and they are changing. And when they are produced, you really have to have some practical terms of when you're looking at COI research is how was that law, how's it come about? And exactly in terms of you have to kind of look at how it's then, of course, implemented. So it's not just, it could be you have a very positive law, but you also need to look at exactly how this is implemented. And the final point before I hand over to Nina is there was all of Thomas's recommendations. He made 12 recommendations and they were fantastic, but there was one recommendation that we would also like to support and highlight. And this was the Independent Advisory Group on Country Information, known as IAGCI, to review COI relating to Kurds from Syria and as well as other stateless communities. And as you can see on the left-hand side, the inspection has actually been carried out, and it was carried out in April this year, and we're just waiting for publication. So we're really pleased that that has happened, and we welcome the results. Back over to you, Nina.
Thank you so much, Fatima, and sorry for rushing you. And I'm sure
Not a problem.
We could spend much more time if we had it with all of you today. So a big thank you to all three of you for sharing your expertise and insights. And if it's okay with everyone, we're proposing to just run over a little bit by 5-10 minutes so that we can take a few questions, if that's okay. Obviously, to the audience, if you have to leave by 12 UK time, we understand. So we're recording the session, so you can access the recording afterwards. But we have had a few questions in the chat during the session, and we had a few questions in advance. So we'd like to address those now if we can quickly. And if you have more questions, please do continue to post them in the chat, and we'll see how many we can get through. So firstly, I wanted to address a question that we had from somebody who registered for the event who is stateless themselves, who asked, they have stateless status in Spain, and is there a procedure to change that status to a UK statelessness status? And I'm going to hand over to Cynthia in a moment to answer that important question, but also just to say we had a couple of expressions of interest and registrations from people with lived experience of statelessness. So it's fantastic to see people with lived experience joining the webinar. So thank you for taking the time to be here and sharing your expertise and experience. If you have more questions, please, or comments or expertise to share, please do so in the chat. We also have at ENS, we really welcome the participation of individuals with lived experience of statelessness in our work, and we have a community group that we facilitate as part of our work, and you're more than welcome if you are interested to get involved. Please do have a look at that on our website, and my colleagues will post a link to more information about that just now. But on the specific question, Cynthia, do you have an answer to that one for us?
Yeah, unfortunately, there's no way to change to kind of convert a stateless status granted in another country to a stateless status in the UK. The UK's statelessness determination procedure actually requires that the stateless person is not admissible to any country, and they won't be granted stateless status otherwise. So there isn't any way to convert that I'm aware of. I would say possibly you could consider other options, for example, work or study visas, if those are things that you are interested in doing. But of course, there may be some obstacles or challenges to doing that.
Thank you, Cynthia. Another question we had in advance was, what are the chances that the global campaign to end statelessness will be extended beyond June 2024? So I think the reference here was to the UNHCR's I Belong campaign. So I can share a little brief update in response to that question for those who are interested. So as far as we understand it, the UNHCR I Belong campaign runs until the end of next year, end of 2024. When a new global alliance to end statelessness will be launched. So it's it may be the end of the I Belong campaign, but there is a new initiative taking shape. ENS is represented on the global task force that's been set up to advise on the formation of the global alliance. And if this is successful in engaging stakeholders, then we think it has the potential to take forward and try to achieve more of the I Belong objectives beyond the campaign, the current campaign. So we have some information that we can share about the Global Alliance. We don't have time to go into detail now, but it's basically been created to try and achieve the vision of a world free from statelessness, so everyone can enjoy the right to nationality without discrimination, and it has some core objectives. So hopefully the end of the I Belong campaign is not the end of a global focus on addressing statelessness, to answer that question. Then we had another really important question from Carmen Wilk from the US State Department. Thank you for your question, Carmen. So Carmen asked, how can lessons learned from this report be applied to asylum systems in other countries, including the US? And I think Thomas perhaps had a few reflections on that question, and then maybe Cynthia afterwards.
Yeah, I mean, I think in general, while this report is clearly very specific to the UK context, and much of it might not translate well to other country contexts, overall, there were some key cross-cutting findings relating to looking into how different procedures are being implemented and operating in practice. I think it would be useful to review US country of origin information to see whether statelessness is properly reflected, to also see how these same procedures are working, and essentially our recommendations of conducting internal or external audits of how the Home Office is operating would translate over to looking into essentially replicating some of this research in the US. I think it's also very important to consult with those who have the lived experience of statelessness, which was a major part of this, the approach of this report. And I know that no doubt you would be in contact with United Stateless, who are one of the key actors in the US as a stateless led organization. So I think they would be able to reflect very well on what might be relevant, what is also the case in the US.
Brilliant. Thanks, Thomas. Would you like to add anything, Cynthia?
Sure. Just quickly, I would say that I echo everything that Thomas just said. Definitely. And I would just say that having a statelessness determination procedure and a refugee status determination procedure that that can cross-reference to each other and cross-refer, really, really important. Also really important to remember that having these procedures in place is a great start, but that's not enough. They have to be robust, effective, accessible procedures that take into account the realities for stateless people and the fact that they're not going to have certain documents. They are coming from very often from a marginalized background. They're very often going to have fear of authority based on their previous experiences. And so there need to be mechanisms and safeguards built into these systems to make them appropriate for stateless people. And we really, really need early screening for statelessness and better attention to questions that seem really simple, like what is your nationality, which we all know is not a simple question at all for a lot of people.
Brilliant. Thanks, Cynthia. And I wondered, Fatima, if you had anything to add to any of those questions. And also there was a question that you already answered in the chat, but somebody was asking where you can find country of origin information used by the Home Office. Is there anything else you would want to add in terms of signposting to that or in response to any of those other questions?
I think I don't have anything to add other than I think Cynthia has completely covered it really well, and so has Thomas. And I think the only point that I might emphasize is that, especially to decision makers when they are working on country of origin information, is that they shouldn't just rely on internal COI products that they have. If they don't have the information, then they should be looking into NGOs or civil society organizations who might have already produced that work. So we can avoid duplication, etc., but we can also have maybe access to information that's currently and up to date.
Thanks, Fatima. That's a really important point. So another question we had in advance was from our colleague Sasha at the NGO 10th of April in Ukraine. Hi, Sasha, if you're joining us today. He asked, are there any registered cases of asylum seekers with undetermined nationality from former Soviet Union countries in the UK? We thought that would be a question to put to you and the audience as well. If you have come across any cases, such cases, do drop a note in the chat. But Cynthia, do you have anything to add in response to that from your experience?
Yeah, so I personally have assisted a couple of people who were stateless from former Soviet countries, and they experienced all sorts of issues, some which were specific to kind of the post-Soviet experience, like not being resident in a particular country at the time of independence, or not having a residence document, a propishka, and then having it not being able to renew it, and then not having being recognized as a national. Both of the cases that I can kind of think of off the top of my head from former Soviet countries also involved really serious issues relating to mental health. And I think that that's probably not so uncommon. And one of them also involved a person who was from a disputed territory and who had lived in several different parts of the Soviet Union. And I think that that's also something that we can think about in the broader context, that, you know, these issues are not specific to the former Soviet countries, that, you know, there are lots of commonalities with other contexts as well.
Thanks, Cynthia. Great. Another question we had during the session just now was from Isatu. Apologies if I pronounce that wrong, but Isatu, thank you for your question. Your question was, what is the impact that displacement, and especially forced displacement to another country, can have on the situation of those who are already stateless? And I wondered, Thomas, would you like to reflect on that question maybe?
Sure, yeah. Thank you for the question. I think it's a very good one. I guess I would respond on two levels. So firstly, there are definitely lots of displacement has lots of impacts for stateless people in terms of their everyday life. It can be very difficult for stateless people to, for example, rent a property if they're in an urban displacement context, to access services. We saw in the Stateless Journeys project previously, often when crossing international borders, for example, Syrian citizens were permitted to cross, but stateless Syrians were held back at the borders by authorities. There were all kinds of issues along these lines. Also, risks of detention if somebody is stateless, unable to prove where they're from and satisfy the authorities. This probably also goes for undocumented people. The second part is, I think there are some specific implications for what the report looks at, which is determining country of origin. So if we just imagine that a 17-year-old stateless Kurd has lived 5 or even 10 years of their life in a displacement context in another country, that's obviously going to have an impact on the knowledge that they have about cultural awareness relating to Syria if they've lived almost half their life in Iraq or in Turkey. And equally, it would have an impact on the way that they use their Kurdish language, no doubt, if they've been interacting with local Kurds from Iraq and potentially mixing with other linguistic influences. That's also potentially going to have an impact on how they're able to navigate the system and be recognized as Syrian. So obviously all of those things need to be taken into consideration. And there's more discussion on these points in the report.
Thanks, Thomas. And yeah, more detail can be found in the report and also on the Stateless Journeys website, as we mentioned already. I'm conscious of time and do want us to wrap up by 10 past. So I know we could spend a lot more time here with all of you. There is one final question from Dervla in the chat, who asked, is there reference to statelessness in the material provided to asylum seekers? And they've given the example that in Ireland, there's very limited information provided. So my understanding from countries that we've worked with partners in is that there is often very limited information. And one of the things the Stateless Journeys project tried to do is produce some information or model template information that can be handed out to refugees and asylum seekers in different countries. So you can find a template leaflet on the Stateless Journeys website. I don't know if Cynthia, Thomas, or Fatima had any specific answer to that from your experience. Cynthia, perhaps in the UK, are you aware of anything?
Well, Judith Carter and I were trying to get the Home Office to add something about statelessness in the information leaflet that's handed to people when they claim asylum. And unfortunately, Judith has gone now, and I don't know where it got to in the end. So we'll have to follow up with Judith if we want to find out if it's actually there or not, or maybe someone in the audience knows, because I've kind of lost track of that over time because I'm not working on that specifically right now. But it was a struggle. They promised they would for many years and then didn't.
I think it's a really important question, and something for all of us to take away and think about is how can we ensure that that information is provided to people as soon as possible on arrival in terms of statelessness and access to rights and information. With that, I'm going to wrap up by saying a huge thank you to all of our speakers today. Thomas, thank you for the really important research and work that you're doing on this issue. Thank you for your interventions today. Thank you, Cynthia and Fatima as well for the fantastic work and your expertise. Thank you to all of the more than